Call the second case on this morning's docket, case number 115006, State of Kansas v. Carlton Lee Mays.
May it please the court, Kate Zigzman on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Judge. This case comes to the court following my client's conviction for theft and burglary involving a shoplifting incident after he had been issued a no trespass order for, I believe, a Dillard's. He was sentenced as a criminal history B at the time of the original sentencing based upon an unspecified Missouri robbery conviction. The PSR did not note whether it was first or second degree robbery, which is how Missouri classifies its robbery. My client was incarcerated. While he was incarcerated, he filed a pro se motion to correct an illegal sentence based on Murdoch because his robbery is from, I believe, 1977. The court issued a summary dismissal. It was before Keel, but after the legislative fix to Murdoch, and then it's been sort of winding its way through the courts since. I have to say that never before has going second been quite the benefit it has been today in watching the court address the prior argument. So with that in mind, I think I'd like to reframe where we are.
Well, yeah, why don't you tell us where you're at, because don't you have a preservation hurdle you at least need to address with us? And that is that when the Court of Appeals filed its show cause, you didn't respond.
There was not a show cause.
Filed it for additional briefing. Where do you stand on that?
The issue was these cases, because it's having to do with the client serving the sentence. The state filed an initial motion for summary dismissal because my client was released to post-release. Then
And then the Court of Appeals said no.
The Court of Appeals said no.
Under sentence, but after that,
the state filed a motion for involuntary dismissal based on his release from post-release, which was just shortly before the summary calendar argument. And so it did not get responded to because the court had already had its summary calendar to meet about the case.
so it was a timing issue.
It's a timing issue in that it seemed like it was moot because the court had already met to determine the case, even though the issue had not been issued an opinion on that.
It was in the pending. It was pending already.
It was pending already, I believe, is the timeliness of that.
Post calendar. So your briefing would have been out of time.
Right. Any briefing on the issue would have been out of time. And so it just happened in a weird procedural manner.
Okay.
But our request is to go back and to figure out what the robbery is so that we can classify it under Keel and move forward. But as far as the mootness doctrine and where the court is today, I'd ask the court to reframe this back to two things. One, does my client have a legal right to a legal sentence? And two, what does the statute say? I know that Justice Stegall was questioning mootness as a jurisdictional issue. This court's case law is that jurisdiction is created by statute. And 223504 says we can file a motion to correct a legal sentence at any time.
What's your understanding of at any time? Is it 25 years from now, as long as your client's still alive?
Judge, that would be the plain language. If the legislature wants to hem us in, that's their prerogative. But any
you
time.
would give a literal kind of at any time means at any time.
I think that's the way the sentence construction works.
You would agree that jurisdiction, it has constitutional contours as well.
I do believe jurisdiction has constitutional
So
contours.
if the Constitution would limit jurisdiction in these cases, in some ways it doesn't matter if the statute tries to give jurisdiction, right?
Correct, but of course then we're going to be parsing apart whatever the language is for the fix to define any time. So we're back to sort of speculation.
What are the contours provided by the Constitution to jurisdiction?
I believe that Article 3 says that this court has jurisdiction as defined by law, which would be the statute, if I'm not mistaken. It's been a minute since I've read Article 3, but I think that's
This
what...
gets back to the case.
Does that not mean that our jurisdiction depends upon the legislature?
I believe it does. to some. I'm sorry. I might misunderstand the court.
Well,
I think
to clarify, we have case law that says we have to have a case or controversy, and
That's correct.
That's really kind of been, forgive my inexactitude here, but grafted on from U.S. constitutional law, from federal law. Is that just wrong?
I don't think it's wrong, but I think we do have a controversy here, regardless, because my client's still entitled to a legal sentence. If his sentence length has a host of other kind of domino effect. It can affect criminal history score in the federal court. It can affect when your right to possess a firearm is restored under Kansas law. It can affect when your civil rights are restored. But if we stand here and try to guess at all the collateral consequences, sort of like the barber, that's not to diminish collateral consequences. They are very real for our clients. But it's sort of hard to guess all of the different things that could go wrong down the line, except for the things that are right now stated as a matter of law. Which is why I think we need to refocus on, does my client have a legal right to have a legal sentence imposed? Which I think he does. If we can't agree to a legal sentence and plea agreements, we can't, I don't think it would be proper for a court to essentially acquiesce by not correcting what is an illegal sentence. Does that make sense? I've rewritten my argument as I sat here.
He served his, I may be getting our 4 cases confused, but he has served his sentence. That's why we're here. Correct?
My client has served his sentence. That is correct. He's also served his post-release. But his collateral consequence has to do with that starting that period to, the one I selected was the firearms prohibition. He's otherwise eligible to possess a firearm under Kansas law, and that time goes from the date of release of prison.
And how does this, and this, that gets to my question in the first case also, how much do we get into the underlying right to possess a firearm? Here, prison release date, nothing changes when he got out of prison. And there's nothing that said when he should have gotten out of prison. The statute says, and you didn't even brief any of this, you just say right to possess a firearm. And so we're left, well, what does that mean? How does that implicate this? And if you just look just at the first question here, it's like, well, he got out of prison on a certain date, and that isn't going to change.
Well, I think because we could, the court could certainly say his release date should have been this, and that's when the statute.
Well, how do you know? Again, that's where it gets very speculative. When you say, if we don't follow the statute, it should have been this. How do you know? You don't know what his behavior in prison would have been. You don't know what would have happened. All of this stuff becomes very speculative.
Well, I think you can.
When you get to asserting that particular right based upon how it's before us now, we just don't know.
I'm sorry, did the Chief Justice have a question, or do you want me to answer that one first?
I'm just listening to the eloquence of my colleague.
Thank you.
I think.
Would you please note that? Worldwide, I guess.
My position would be that we actually can calculate what the sentence should be. My client has a huge disparity between the guideline sentence as a B, what his sentence was because he got a downward departure, and then what his sentence would have been if he was a C. So even if we recalculate, say he lost all his good time, that still moves the date back.
But it doesn't move his release date.
Right,
That's
right.
my colleague is saying it's the statute says 10 years, quote, has been released from imprisonment for such felony, end quote. And it doesn't say when he's completed his sentence for that felony or anything like that. It's the release from prison is what triggers the 10 years. And if he was wrongfully imprisoned for 10 extra years, too bad, because the statute says release from prison. And you know, the underlying rationale for this prohibition is to integrate them back into society without having firearms.
Well,
And so that even if they were serving a longer sentence, arguably that rationale was accomplished by this statute.
Well, and I think that's probably why I rewrote my argument sitting here. I think if we get back to the plain language of the statute, and does my client have a right to the imposition of an illegal sentence? Because the court's not wrong. There is a host of speculation. We don't know if there'll be a malpractice claim. We don't know what all these other things will be. But if we refocus on, does my client have a right to have a legal sentence declared for his case? And the rest of it will have to come up as it comes up when the case is actually ripe for consideration, as opposed to speculation regarding all the what ifs and could be's that occur. And part of why I think we should refocus on the issue of imposition of a lawful sentence is that in the case of if my client does pick up an unlawful possession of a firearm, and we're arguing over what date of release from prison means and when he should have been released and those kinds of things, we can't really do a collateral challenge to the underlying sentence or conviction in that instant case. We're not allowed to bootstrap the priors into a collateral challenge. So it comes back to the fact that each defendant has a right to have a lawful sentence imposed in that case. And while it may not have a direct, immediate get out of jail effect, it does not take away from the fact that there are a host of effects that occur down the line, and my client does maintain a right to that a right to a legal sentence.
Even after he's completely served what might have been illegal. That's your whole argument.
That is my whole argument. I think the court has an interest in getting it right, is my position, and that the defendant should be entitled to the court getting it right.
So we're not even talking about mootness here.
I'm trying to pivot away from mootness because I think that that right to a legal sentence really covers all of the different bases. It covers the people that are still incarcerated and will get immediate relief. It covers the people who have been released and come across these collateral consequences down the line, especially with that any time language.
That argument's undermined a little bit, and I wish I had the name of the case. I think maybe it was Gaudina or so, I don't know. But we had a case in which a person served longer in prison
Right.
than they were supposed to, and they wanted credit against post-release supervision. This court said no.
Right.
And so they basically had no right to the legal imprisonment. They just lost it.
Well,
And so if that's the case, how does that translate to your client having a bigger right than the person that actually sat in prison too long?
Well, Godina is the case the court is thinking of.
Okay.
And that had to do with interpreting the two separate statutes that govern post-release and incarceration. So we're back to statutory construction again. In that the statute related to post-release supervision didn't allow for credit forward. And the legislature can change that if they want. But because we're dealing with two specific statutes, that's why Godina doesn't necessarily cut this off, because now we're talking about a separate issue. Does my client have the right to have a lawful sentence pronounced in the case where the unlawful sentence was imposed, so that he can take that and deal with the barbershop or whatever else comes forward, because it is difficult to know what's going to happen in the future. There's a few things we know happen automatic, like the restoration of firearms rights or the restoration of civil rights, or the criminal history score for federal court goes off of your sentence length as opposed to the type of conviction. So there are some things that are automatic, but there's a host of other things that are very real that should be governed more by, was the court right? Did my client have a legal sentence? And then we address how that's interpreted in a separate action when we have an actual set of facts to consider and rule upon.
So if your client wants to be a gun-toting barber, somebody will address that later.
Yes, when he gets denied his right to have a firearm and gets charged with unlawful possession of a firearm, I'll be back arguing something similar. And if he wants to be a barber, then he'll have to find a civil lawyer that does civil administrative licensing appeals. Thank you, Judge.
Any more questions? Thank you, counsel.
May it please the court, Sean Minahan for the state. I want to talk about something that hasn't been talked about today, and this is more of a practical argument, and this court may not care at all about it, or may, but let's say Mr. Mays gets his sentence reversed, and he goes back for sentencing. And what actually will happen will either be the prosecutor or the judge emailing me and the defense attorney saying, what am I supposed to do with this? He's already served his time. And saying, well, you know, the Kansas Supreme Court says that you have to resentence this guy, so we need a resentencing. And because it's a sentencing, he has to be there.
Not all of us say it's a resentencing, because it's a motion to correct an illegal sentence. You correct the illegal sentence. Some of us say that you can correct the illegal sentence and not that you resentence. And that's important because it has to do with the exercise of discretionary matters.
That would start...
And you can't go to the high number if that's not in the box or something, if that's not in play or whatever.
Yeah, and that certainly is a distinction that would be important for this court to consider on these cases.
Well, that's what I asked Ms. Roth, kind of the practical considerations here on a resentencing, because that's the relief that is sought in all these cases is a resentencing.
Right.
So yeah, what would be the practical consideration? Yeah, the defendant would have to be present. Why is that a hurdle?
So judge does an order to appear, and what if the defendant doesn't appear? Do you do a bench warrant for a guy that's already completed his sentence? Have him arrested? He has to bond out or stay in jail until the next hearing? That just seems so for a case where he's completed everything he's supposed to do in the case and been discharged, to have to come back and be arrested is...
But we've corrected, for instance, the imposition of post-release supervision in an off-grid is illegal. You have to have lifetime probation, right? And we've just sent down and says, you know, change it. You don't have to have a new sentencing, right?
And I agree with you.
Yeah,
Your
we
Honor.
just vacated it, or whatever.
But it's going to be an important distinction for this court to make, because if you send it back and say resentencing, the court's going to have to resentence.
Right.
And so that's going to be
And if
an
you get
important-
another grid box, they have to select a grid box, a number in the grid box.
Right, and who bears the burden? Well, you know, it seems to me that we're trying to balance a defendant's rights with judicial economy, and also that this is ultimately going to be on a case-by-case basis. What I think should happen is the state files a motion to dismiss as moot. The defendant can then respond saying, you know, I have filed this lawsuit against my, against my defense attorney, or I have, done paperwork because I want to be a barber, or whatever, and explain how this impacts him. And then the state can respond, I suppose, and say, well, he has administrative remedies to do this instead. And it becomes the court's discretion on whether to dismiss it or continue with it.
Go ahead.
What is the action that the state is filing a response to argue that this is moot?
I'm sorry? I don't know.
There has to be something that the state reacts to before it files something to say this controversy is moot. What is telling the state what the controversy is?
That he's completed his sentence.
So this is something that the defendant in this case would file?
No, so the state would file a motion to dismiss because the defendant has served a sentence.
Didn't you do
It is
that?
what, it's dismissing what?
A sentencing appeal or a revocation or whatever.
Well, there's a step ahead of that.
Okay.
First, you look to see what the defendant asked for. And with the new knowledge that they're out of jail, you look and see the defendant asked to be resentenced, and so based on the remedy that was asked for, you say, wait a minute, there's no point to that.
Right.
Therefore, it's moot. I mean,
Right.
that's the sequence.
And in that's what happened here.
Yes. I've never seen a case, and the request, and maybe this is where this goes, that the request for relief becomes a much more important factor in the, having done hundreds of these, you just put, this is a sentencing appeal request for a resentencing.
But if the relief is to reclassify
Right.
a prior conviction, does that apply anywhere except in the current proceeding? In other words, does that correct the classification that was used in the original sentencing on the prior case? And specifically what I'm thinking about is a pre-apprendi conviction. We already have case law that says you can't change that conviction. You may or may not be able to change the classification for current sentencing. So if you did, you could change the classification for current sentencing, but that's not going to change the fact for civil consequences that you have that conviction still on the book.
Right. No, I agree with that.
So you would agree that changing the classification to use in the current sentencing wouldn't give the defendant the relief that he or she needs for civil consequences?
If it's based upon the prior crime, right? Yeah. And I haven't looked closely, but can you appeal asking just for a reclassification of a sentence? I don't know. And so this is kind of maybe a new area of law, or a new area that is going to be focused on. What are you really requesting? So, and I think one of the other concerns is with this, if the defendant has served his sentence and he wants a reclassification of one of his prior crimes, what's the incentive for the state? Is the state really the party that cares at that point? Does the state want to...
Well, apparently you do. I mean, you're the one who says it's moot. If you didn't care...
No. In the sense that if he's already served his sentence, he wants a reclassification so he can sue his defense attorney.
Well, or in this case, possess a firearm.
Yeah. But if it's, let's just use the suing the defense attorney. The state really doesn't have a lot of care, Johnson County District Attorney's Office or, the county attorney on the defense attorney. Of course, they don't want other defense attorneys sued, but it's not really their...
They don't have a dog in the fight.
Yes, thank you. And so are we going to spend all the,
Use
do all
resources
to object and to do the appeal, or are we just going to sign off on it because it doesn't really affect our, so isn't really the person who should be the party in that decision the defense attorney in that specific case? So does that make sense?
Well, so are you abandoning your position here today because you don't care?
On mootness?
Yeah, I mean, what do you...
No, I'm just... Everybody else, you guys have been talking about this all morning, so I'm just trying to...
Right, I understand.
Explain kind of some of the nuances, the practical effects of some of these things.
So, just so I'm clear, are you saying that this is moot
Yes.
But the defendant in this case has other legal options that would not involve your office.
Right.
Is that what you're saying?
Yes. It is moot because he served his sentence. And, I know the defense attorney keeps on saying he has a right to a legal sentence. There is no sentence. He's finished his sentence. There is no sentence left. And so, unless this court has any other questions.
Any further questions? Thank you, counsel.
Just a couple points that came to me as the state was arguing. The state files a motion to dismiss for mootness. Since they are the moving party, I think they bear the burden to demonstrate the mootness. It's sort of like an affirmative defense to the claim. So I think that answers the court's question as far as who has to carry the water for determining mootness. And it would be the person who moves to dismiss for mootness or who would benefit for the mootness. The other issue is the court mentioned, reclassification versus resentencing, but Chief Justice mentioned why can't we just get declaratory judgments to go back and address civil consequences, and what's really the difference between an order reclassifying sentence and a declaratory judgment for whatever collateral purposes are. It still takes up the court's time. So there's not any judicial economy gained, but we did shift that burden to an often indigent defendant who is trying to deal with some sort of collateral consequence that's probably affecting his livelihood at the very least, so that he has to either pro se file for a declaratory judgment or find an attorney to do it for him. It seems that the motion to correct a legal sentence with its anytime language is the way to get the reclassification.
What relief are you seeking right now? I mean, are you just saying that in the posture of your client, once he has completed his sentence, it is never moot, or it's not moot?
I would say that because my position is my client has a right to a legal sentence, whether or not his sentence is illegal is never going to be moot. But in this case in particular, there is a controversy because we don't know what the Missouri robbery is, so we can't even begin to approach a Keel analysis. We're slightly differently situated from Ms. Ross' client because they at least know they get Dickey relief. We don't know. It could be we go back and he's right back where he is, or he could be a C or a D. We don't know.
Counsel, I'd like to go back to how opposing counsel started his argument, and that was under the umbrella of practicality or common sense. Mm-hmm. So I want to go back to one of your points just a minute ago on why you believe it's the state's burden to prove mootness because they're the ones who filed the motion to dismiss based on mootness.
Yes.
From a practical standpoint, in looking at our test from Montgomery, does the state just say it is moot because, and it gives its reasons, and they have to anticipate all the arguments that you would come up with, such as, well, my client wants to be a gun-toting barber, and they put that allegation in there and why it's not effective? Or do they file their motion and then you come in and say, well, my client wants to be a gun-toting barber, here's why it's therefore not moot? Is that where we are practically?
Well, I think practically speaking, it would be easiest to sort of mirror a 1507 procedure where one gets filed, the state responds, the court decides if it's going to summary dismiss it, appoint counsel, have a hearing, or whatever the case may be. I think that similarities in procedures are helpful for district courts so that we have kind of the similar way of doing things. So that would sort of be the analysis. The client would file a motion to correct a legal sentence. The state would say it's moot. And then the defendant would have to most defendants, well, I don't know that we can say what. They're not, right, I think the judge would have to appoint counsel and then determine what their allegation is. I think practically speaking, most defendants would probably file something that said, I want to be a gun-toting barber and I can't because of this case, just because that seems to be like a practical common sense man off the street way to approach something, but there's no guarantee a pro se defendant would do that. So I think that that would then trigger the court saying, well, this guy's sentence actually was illegal. Is it moot? Let's appoint an attorney to determine that mootness factor.
And what happens at the resentencing?
What happens at the resentencing is the judge does a nunc pro tunc, says you're really a C, your sentence imposed was this, and that's it.
But we've said, I believe, that on a correction of a illegal sentence, when it's sent back, it can be changed to consecutive instead of concurrent.
It can, but I believe, and forgive me, I'm not sure if it was this court or the Court of Appeals, in the last week or two issued a sentence or an opinion about imposing punitive sentences for seeking appeal or post-conviction relief. So then we'd sort of stray into that area if the court is trying to give them
appeal.
Well,
right.
And here, what you have too was an agreed upon sentence of
Correct.
70 months.
Right.
And it just seemed, and there's part of the statute is you can't appeal an agreed upon sentence that's imposed, and so there's that issue also that kind of intermixes with any potential resentencing.
It's not clear cut, but I
No,
think
no.
that if we determine that my client is entitled or his box is less than what he agreed to, then he can't agree to that illegal sentence. So we'd have to do a little renegotiation, or just take the guideline sentence, or it's going to get messy.
Any further questions? Thank you, counsel.
Thank you, Judge.
We thank you both for your arguments this morning. Court will take this matter under advisement.